The prosecution and defense in the Sean Combs criminal case fired shots back and forth in court as the government has been accused of violating the embattled rapper's rights. We're going to break down the backstory, the arguments, a slight win for Sean Combs, and maybe how all of this could affect his potential bail. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Sean Diddy Combs was back in court yesterday, and it was a day that put the prosecutors in the hot seat, with the rapper walking away with a little bit of a slight win. I'm going to explain, but before I even get into what happened in court yesterday, I need to provide you backstory on what led to this and what happened. So as you know, Sean Combs is locked away in the Metropolitan Detention Center out in Brooklyn, New York. And this is as he awaits trial next year on federal sex trafficking, racketeering, prostitution charges, again, that he used his wealth, his power, his influence, his businesses to further a criminal enterprise that was engaged in a number of different illicit activities. But most specifically, the freak-offs, right? These coerced, elaborate sexual performances that were sometimes drug-fueled, that involved male sex workers. You know everything by now. But here's the thing. Combs has been trying left and right to make bail, to get out of there. And he has already been denied bail and pretrial release by multiple judges. But here's the thing. This Friday, and we're going to cover this here on Law&Crime, he is set to make his argument once again, but this time in front of a new judge, Judge Arun Subramanian. So this is the new judge overseeing this case. This is a judge who hasn't heard the bail issue before. And we have already seen briefs back and forth from the prosecution and the defense about why Combs should or should not get bail. But that brings me to what the prosecution alleged most recently, and we did a sidebar about this, because they claim that while behind bars, not only are prosecutors continuing to investigate Combs and presenting evidence to a grand jury for possibly a new superseding indictment with potentially more charges, but they have been actively monitoring him. And they say that Sean Combs has not only broken the jail rules, but he is possibly engaged in obstruction in this case. And therefore, he can't be allowed out on home confinement. By the way, as you may know, we have been trying to cover every major development in the Sean Combs case for you. And for that, I gotta thank our sponsor, Morgan & Morgan, because they help make episodes like this possible. Now, here's the thing. If you should get injured, America's largest injury law firm, they may be who you want in your corner, okay? Because not only are you talking about over 1,000 attorneys and additional support staff, not only is the process super simple because it can all be done right from your smartphone, not only is there no upfront fee, but with Morgan & Morgan, they have an incredible track record. Recent verdicts, $12 million in Florida, $26 million in Philadelphia. All of these, mind you, considerably higher than the highest insurance offers in these cases. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar. So in their most recent filing, the government writes, the government's grand jury investigation of the defendant, including the defendant's obstruction related to this criminal case, is continuing. As part of that investigation, the government has sent grand jury subpoenas and document requests to the Bureau of Prisons, the BOP, for the defendant's monitored communications, including calls and emails. From those materials, the government has learned that the defendant has persisted in engaging in obstructive conduct since he entered BOP custody. Among other things, the defendant has engaged in unauthorized communications practices, including three-way calling on the monitored phone lines, use of other inmates' phone access code, or PAC numbers, to make phone calls on the monitored phone line, and use of a third-party text messaging provider through the BOP's monitored email system. Each of these methods of communications is prohibited by BOP. Furthermore, as set out in the government's November 15, 2024 brief, the defendant used these unauthorized methods of communications to continue to engage in obstruction, including by instructing third parties to reach out to witnesses and attempting to influence the jury pool in this criminal case. Now look, prosecutors, they previously cited as an example this call from October 4th where apparently he's speaking from jail to one of his adult sons, and while the content of that call is redacted, the government said that this is a clear inference that his goal is to blackmail victims and witnesses into silence. They also say that he enlisted his family to create a social media campaign around his birthday where a video was posted online of them wishing him happy birthday over the phone. You actually hear him on the other line. Again, this is when he's behind bars at the MDC. And prosecutors say this was done to influence a potential jury pool. But they also say they have evidence that Combs may have paid off a potential witness. Now, how do they know that? Well, they explain that there were notes recovered from his jail cell during a widespread sweep of the MDC. And that is the issue. And we've talked about this before, but the MDC is a mess. It is plagued with violence. It is plagued with smuggling. And so there was a raid. And prosecutors explained that back on October 28th, the Bureau of Prisons and other agencies swept the MDC. This was pre-planned. It was done to ensure the safety and security of staff and inmates. This wasn't just focused specifically on Sean Combs, but multiple housing units were searched and electronics were found, homemade weapons were found, other contraband was found, but they did search Combs' bunk. And prosecutors indicate that, look, they were aware in advance that the sweep was happening, and they were aware that Combs' cell would be searched, but the prosecutors made clear they were not part of this search. This was the Bureau of Prisons. But prosecutors admit that they are now in possession of potentially privileged materials, meaning attorney-client or work product materials. But they say, don't worry, these already went through a filter team before they came to us, so to make sure there's no privilege issues. By the way, when we're talking about privilege, attorney-client privilege are those private conversations between a client and a lawyer about representation, about the case. And work product are materials made in anticipation or preparation of trial. And generally speaking, both can't be used by the other side of trial. Well, the defense, as you can imagine, was not too happy about this. So they wrote in a filing, defense counsel has recently learned that the prosecutors are in possession of attorney-client privilege material, including the defendant's own written notes. This search and seizure are in violation of Mr. Combs' 4th, 5th, and 6th Amendment rights. Moreover, the targeted seizure of a pretrial detainee's work product and privileged materials created in preparation for trial is outrageous government conduct amounting to a substantive due process violation. Because the prosecutors are currently in possession of privileged material and are actively using this material to detain the defendant, the defense requests an immediate evidentiary hearing. And yes, the judge ordered this emergency hearing. This was yesterday. This is what we're going to talk about in a little bit. But just to give you an idea of what we're focusing on here, this was the prosecution's argument. They said they did nothing wrong. As I mentioned, they said, look, we weren't part of the sweep at the jail. There was this investigator from the Bureau of Prisons who was there. He interviewed Sean Combs about contraband, and he found in Combs' bunk or on Combs' bunk a manila folder marked legal, another notebook, an address book, and some personal effects of Sean Combs. He ended up taking photos of the notebook and the address book, but he didn't take anything. But to be clear, since a lot of this is redacted, we don't really know exactly what the contents of this notebook were, but this investigator alerted prosecutors that he took photos, and he said that the notebook was about Combs' notes to himself. Now, prosecutors said, okay, we want to be completely safe on this. Send all of the photos to a filter team, make sure there's no privileged materials. After that filter team reviewed, they sent certain photos to the prosecution team, and the government admits, yes, we used these photos of Sean Combs' notebooks in our motion to oppose his bail. We used it. For example, there was evidence from these photos to prove that he had paid a potential witness. And they argue that despite the defense's claims, this wasn't a targeted seizure of the defendant, and the photographs didn't violate Sean Combs' constitutional rights. The defense, they responded in their own filing. They wrote, the government's letter only reinforces the fact that the government has committed an egregious, willful, and harmful breach of the attorney-client privilege and has become privy to defendants and defense counsel's trial strategy, including areas of expert testimony, witness strategy, and other confidential matters. They say this investigator actually took photos of more materials than the prosecution claims, namely that he took photos of several legal pads. And the defense says that of the 19 pages the prosecution had sent over to them, these kind of photographs that were recovered, 11 of them are Sean Combs' notes to his lawyers, actual conversations about trial preparation and bail. His defense team writes, on top of his legal pads and notes, he has a folder marked legal. This is to put anyone on notice that everything along with the folder marked legal is exactly what it says. Legal attorney-client materials that he brings to his meetings with his lawyers to prepare his investigative and his trial strategy. Two different arguments, two different sides. Now we have this hearing from yesterday to get to the bottom of what happened. Now, to be clear, this is what we do now. There's no cameras in the courtroom, unfortunately, so we're doing our best to report to you about what happened. It was reported that Sean Combs appeared in court, that he was wearing a tan olive jumpsuit, similar to the one that he wore last time, maybe the same one he wore last time. The judge actually, by the way, granted the defense's request for Combs to be unshackled too, maybe even for the future proceedings as well. And from there, the arguments began. Again, no cameras in the courtroom, electronic devices are limited, so this is the best recap we can do based on the reporting. So Combs' lawyer, Mark Agnifilo, told the court that he believes that this sweep of the MDC was actually a pretext to target Sean Combs. He explained that this is a clear violation of Sean Combs' constitutional rights, that he has an expectation of privacy in his legal notes. Few things, by the way. Let's talk about this. So he is correct. A criminal defendant does have privacy rights in privileged documents, conversations, materials. In terms of a Fourth Amendment right against unreasonable search and seizures, that privacy right, that is limited in a detention context because those rights can be trumped if there are issues with maintaining security and order at a jail or prison. But Mark Agnifilo also reportedly says he wants the surveillance video of the search. He wants the communications about the investigator. He wants to know the role of the United States Attorney's Office, who said what to whom, whether there was even a violation of Sean Combs' Fifth Amendment rights. And that deals with self-incrimination, but more specifically due process rights, how the government can't take away your life, liberty, or property without due process of law. And get this, Agnifilo says this is so bad, this is so egregious, he may ask that this whole indictment be dismissed, or he may ask that the prosecutors have to recuse themselves. By the way, you might be saying, that seems not like it's ever going to happen. That seems nuts. Go back and watch what happened to Alec Baldwin in his manslaughter case. The prosecutors withheld evidence in that case. The judge was so angry at this violation, she threw the whole case out. Anyway, from there, going back to Judge Subramanian, he turned to the prosecutors and he said, what's going on here? What happened? To respond to that, we had U.S. Attorney Christy Slavic. And she reportedly said that the 19 pages from Combs are about paying off a witness and finding dirt on victims. That's not privileged material. A little bit of a side primer here on that. So materials that are about ongoing or future crimes are really not protected by privilege. But she also emphasized that her team had no contact with the Bureau of Prisons or this investigator. They didn't even know that the investigator was going to be part of this sweep. She claims that their team only found out about these photographs after the sweep, not like they directed this to happen. Now, the judge apparently pressed her on how this investigator was monitoring Combs and his communications and asked if what had happened is a Fourth Amendment violation. Slavic said, yes, he provided us materials, but this investigator, he doesn't work for us. He works for the Bureau of Prisons. He's focused on safety. And if the defendant was in compliance with Bureau of Prison rules, which she says he was not. Judge Subramanian asked if there was any other material that was photographed here that they should be talking about. And Slavic indicated she didn't know what else the filter team may have. So you're seeing that separation between the prosecutors and this filter team. By the way, we don't know exactly who this filter team is, but again, this filter team. There was also this interesting reported exchange where Judge Subramanian asked Prosecutor Slavic along the lines of, is it standard procedure to photograph notebooks rather than take them so it could be known they were taken? To which AUSA Slavic apparently responded, I don't know. But Slavic reportedly doubled down, saying they don't have to tell the defense of an ongoing investigation into Sean Combs. And plus, we sent the materials to the filter team. If there was a privilege issue, they would have caught it. To which Subramanian reportedly asked if these were verbatim notes of Combs meeting with his lawyers, how would you know that unless you ask the defense? To which Slavic says they rely on the work of the filter team. They trust them. So Judge Subramanian expressed what seemed to be concern at this dividing line between a covert investigation and discovery. What needs to be turned over? What needs to be told to the other side? Since Sean Combs has already been charged. And Slavic reportedly responded, we have an ongoing grand jury investigation for conduct that Sean Combs has not currently been charged with. And there's no authority that we have to tell them what is going on. And this was another interesting back and forth between Judge Subramanian and Prosecutor Slavic, where he asked Is any of this material privileged? And Slavic seemed to respond that the notebook was labeled things to do, not attorney-client. And as to the claim that the papers were supposed to be in the folder marked legal, she said self-labeling is not enough, especially when they say this is about action items involving non-lawyers. There's no privilege here, like it's stuff about family members and birthdays and financial advisors and inspirational quotes that it has nothing to do with the case at all. So Judge Subramanian also asked, would prosecutors be willing to turn over that surveillance video of the search to the defense? To which Slavic said they are opposed to doing that. And it was interesting because at one point, the judge apparently said to Mark Agnifilo how prosecutors kind of want to work with the defense to resolve this issue. And reportedly, Agnifilo didn't seem too keen on that, reportedly said, we don't want to give them any insight. And he fired back too, Mark Agnifilo. He said all the legal pads here, they say legal. That the photos taken were from pads marked legal. That the government isn't being accurate about what happened here. That everything in these pads are things we discuss with our client, trial strategy, who we should speak to. Everything is about the racketeering case. That Sean Combs' to-do list, that is privileged. That this is the heart of attorney-client privilege. Mark Agnifilo said virtually every single thing in these legal pads are matters he discusses with his attorneys. And he called this whole seizure a complete institutional failure. Now, in the end, here's what the judge decided to do. He told prosecutors, get rid of the copies of the 19 pages of material. Get rid of them. And he wants copies sent to him too so he can see what's going on. And he also indicated that prosecutors will not be able to use that evidence when they argue against Sean Combs' bail this upcoming Friday. That's a blow to them. That's a blow to their case. And by the way, as I mentioned, there is going to be a hearing on Friday regarding bail. We will cover it here on Law&Crime. Now, in terms of whether there were potential privilege issues, whether there were privilege violations, he's not ready to make a decision on that. Wants both sides to prepare arguments, briefs, and then he'll decide that at a later date. But it seems that the filter team can still keep the notes at issue as long as they are not part of the prosecution's case, as long as they're not part of prosecuting Sean Combs. They have to be separate. Now, I do have to leave you with one final tidbit from this hearing. Came at the very end, but so important. So the judge, in regarding bail, again, which is going to be talked about on Friday, he asked about the Mike Jeffries case out of the Eastern District of New York. This is something we covered here on Sidebar. This is the former head of Abercrombie who was arrested and charged with sex trafficking recently. He was arrested and charged after Sean Combs was released. And he was released on $10 million bail. Sean Combs' attorneys made that argument. Why is it fair he gets out and not our client? And you know what Judge Subramanian said? He advised the prosecutors, be prepared to explain that difference between that case and this. So that is a slight opening for Sean Combs that he may have a legitimate argument for why he should be entitled to pretrial release, especially when he has put forward a bail package of $50 million, home confinement, 24/7 monitoring, and so forth. So you couple that with the fact that prosecutors can't now use some of that evidence from the jail in their arguments in opposition to bail, that's a slight win for Sean Combs. He has a better shot maybe for bail, but we'll see what happens Friday. That's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.